afternoon and welcome to today's Bright Ideas Lunch Hour program. Today's session will discuss digital frontlines, protecting and litigating IP in the age of cyber threats and tech complexity. This discussion is sponsored by the Intellectual Property Law section of the New York State Bar Association. If you have a question during the session, feel free to unmute your audio and enable your cameras or submit through the Zoom chat box as we encourage you to jump in and engage during or in the open discussion after the program. At this time, Bill Samuels, Intellectual Property Law Chair, will introduce our speaker. Bill?
Hey, everybody. Thanks for coming. Wanted to introduce Ahmad Alokush, who is a technology expert and head of Ahmadeus, a tech development and security and consulting company. He has a great deal of experience in bridging the gap between technology and how it's treated in the law. And on that note, take it away, Ahmad.
Thank you guys, and thank you, Bill, and for hosting me, and Charmaine, and everybody at the New York State Bar. Pleasure to be here. So my name is Ahmad. As Bill has mentioned, I run a software development firm called Ahmadeus Technology Boutique, and through that we work with different types of clients, from big names like Goldman Sachs and Morgan Stanley, and to Barclays and other entities. And during this work, we get involved in litigation cases, and because we do a lot of cybersecurity work. So I'll tell you more about that. Can you guys see the screen properly or no? Yes? So this is the list of the clients who we work with, and we do: software development, AI, cybersecurity. Because of the cybersecurity and all of the work that we've done there, we started getting involved about 8 or 9 years ago by lawyers who were asking us to explain, what does this document mean? What is this word? And from that, we got involved in tech forensics and e-discovery and incident response, breach analysis, due diligence for tech, which spans multiple areas. So there's no one size fits all in the world that we operate in. We have to build custom solutions, custom strategies, and that's where I want to start the conversation at. So I'm going to show you the digital IP roadmap, and I'll try to make it into phases, exactly how we approach IP protection and litigation support with clients across different industries. I don't want this is not an academic presentation. It's the same framework that we use with Fortune 100 general counsels when they call me at midnight because they've discovered a potential breach, or AM Law 100 firms who need expert support for high-stakes litigation. So we'll start with the modern IP threat landscape because it has changed dramatically. And I'm going to be building up the progression of one phase to another phase strategically so that you know it gets built towards a conclusion that can help people here. So after modern, we go from patents to proprietary code, and what does that mean? This is not going to be only focused on software companies per se, but across different industries. I'll try to keep it universal. I need to talk about the threat landscape at phase one, because you cannot defend what you don't understand, and from there we can narrow down the specific nature of modern digital IP across industries. And then in this phase, I'm going to talk about what does modern IP theft look like from what we've seen. Not a specific use case per se, but like a generalized composite use case. And try to break it down to different industries. Doesn't necessarily have to be technical. I mean, most of it is not going to be non-technical, actually, but more talking about what we've seen and the human behavior around it, and how do you understand that? Every industry has its own digital assets that require specialized protection and investigation techniques. And then we'll talk about where theory meets practice. Red flags discussion will give you specific warning signs that should trigger immediate expert involvement. I'll tailor it for different industries. And I'll tell you this: the red flags really are important. A lot of lawyers tell me wish they'd known these indicators earlier, because proper timing can be the difference between preserving critical evidence and watching it disappear forever. It's like, the same idea when someone tells you just hit the gym, stop with the sugars, exercise a little bit, and then, or which is preemptive, being healthy versus somebody having open heart surgery. That's the same idea. And then we'll tell you some action items. I want to leave you with some stuff that you can implement. Um, they're not going to be aspirational suggestions, but specific steps that we've successfully implemented with hundreds of clients across pharma, manufacturing, distribution, technology companies. We'll try to give you some cost considerations and timelines. And again, I want to clarify the Q&A and strategic discussion will be throughout. So I cannot see the because I'm in the presentation mode, I cannot see if any questions come up. So if somebody asks a question via chat box, please, Charmaine or Bill, let me know. But I'm continuing with the presentation, assuming. We're good so far, guys?
So far, so good.
Okay. So let's move to the modern IP landscape. What we're seeing in 2025 across all industries is that the landscape is shifting from what, well, I'm sorry to say, some lawyers thought that trade secrets were living in filing cabinets and proprietary information were sitting in isolated file servers. Like, this is the secret sauce, and I put it in this file server or all the way in the back of the company. Now, I want to explain to you, these trends that I'm seeing are based on multiple industry sources that I've seen, from cybersecurity agencies, CISA reports, Ponemon Institute studies on cost of data breaches and detection timelines. There's the Verizon data breach investigation, which gives you annual finding. So, AI model theft has increased significantly across industry, based on FBI's IC3 reporting and our direct case experience. This is not just seeing it in software companies. It spans every industry where competitive advantage depends on proprietary information. So we're seeing, when I say significant, more than 50%. And across that, we've been seeing source code increasingly being targeted in the breaches. This doesn't have to be something. Source code doesn't have to be for software companies only. It could be a source code for a CAD file for manufacturing firm, for next generation equipment, or logistics company where route optimization algorithms were copied during a consulting engagement. So this is a kind of a dangerous thing. And the detection timeline for this changes based on the industry, I should say. But it does go unextended for IP theft does go undetected for long periods of time, 287 days. But even within industries, it could be a little bit higher. So I'm giving you a generalized one, but sometimes it could be a couple of years. That could be source code, could be drug formulation, manufacturing processes. Your competitors could be using the provided information for nearly 10 months before you discover theft. And by that point, they've reversed engineered your process, filed competing patents, and probably launched competing products. Attack vectors. In cybersecurity, what attack vector is basically the people who are attacking you, the bad actors. The distribution is based on the industry, but insider threats are going to be, majority of the cases. So for example, IP theft, including rather than external attack, is usually manifesting differently but the same. In different industries, we'd find it like in pharmaceutical, systemic theft of clinical trial databases. Submission documents that are regulated, people access them who are not supposed to see it. Compound libraries. Compounds are chemicals that big manufacturers need to create stuff from. Research scientists are recruited just not for their expertise, but for something else. In manufacturing, what we see is something is often the CAD files, a process optimization data. It could be something that people attack, quality control procedures, and supplier relationships. An engineer who's departing with access to manufacturer specifications can enable competitors to basically reverse engineer the product line. Direct cyber intrusion, we still see that. It's still about 25%, but it's still happening. So you have people trying to basically attack your firm, hackers, and persistent, but the increase has been in insider threats, majority of cases. Supply chain complexity can add more problems to this because you have growing threat from contract research organizations. For example, in pharmaceutical companies, CROs, the system for CROs is for accesses the company's clinical data in different areas, research and manufacturing. And if that gets penetrated, then we have a big problem here. I don't know if I'm using too much technology buzzwords, guys. I hope everybody's gone with me on this. Good. So let's talk about the high value targets. In tech, it's ML training data sets, machine learning training sets, proprietary algorithms. In pharma, it's going to be clinical databases worth tens of millions in development costs, drug formulations, decades of research, regulatory packages that cost hundreds of millions to compile. Manufacturing, we see CAD files for precision equipment, very specialized or up to large machines. We see process specifications that provide advantage for quality specification, for product differentiation. In distribution, the IP that we see, which can be considered as customer behavior models, pricing algorithms that optimize profit margins, logistics systems that provide delivery advantages. We're good so far, guys. So I'll give you like a quick one. Like last quarter, we were looking at a case where a departed pharmaceutical project manager did not steal any drug formulation. They copied the clinical trial management database containing patient response data, adverse event patterns, and efficacy benchmark for about 47 different compounds. This data was about 12 years of clinical research and would have cost competitors $200 million plus to replicate through legitimate trials. So this guy was just copy, and we'll talk about how people copy and how can you detect that. Any area you guys want to focus on, or if not, we'll move on. From patents, so in this slide, we're going to talk about the fundamental shift we're seeing that affecting every industry. That the transformation is happening from physical IP protection to digital IP security. Whether it's drug formulation, manufacturing process, or source code, the challenges are basically the same. We're seeing them. The traditional IP is patents, trademarks, copyrights. Modern digital IP for tech is source code, algorithms, ML models, cloud configuration. This is a really big deal. So the IP doesn't have to be just the what you expect as the source code algorithm. How do you set up the cloud? How do you set up Amazon Web Services? How do you set up Google Cloud to make sure your system or your AI engine is running properly? In pharma, as I mentioned, clinical databases, research protocols, regulatory dossiers, that's IP. It's way beyond patents. Adverse event correlation, efficacy benchmarks that inform drug development strategies, research protocols that in collaboration. If you store that with the platform revealed experimental approaches, that competitors can repeat that. In manufacturing, we have CAD files. Modern manufacturing relies on digital twins, the CAD repositories and process optimization databases. They have quality control systems, supplier data, and the relations that they have. This can be part of your IP. In the distribution area, we have customer lists, databases, pricing algorithms, route optimization systems. If you can copy this information, you can do something called precision targeting. You can do optimal pricing and efficient operation. So universal challenges, I would say, in this world is, well, I'll give an example. So pooled digital asset inventory. Most people don't even know what they have and what can they do with it. How can they handle it? Like I'll give you 3 different companies we work with: a biotech firm, an aerospace manufacturer, and a global logistics provider. And when we work with them on cybersecurity, and part of that is doing an IP inventory project, we discovered that the same thing exists. The shocking reality, their digital assets were scattered across dozens of platforms, poorly cataloged and not properly protected. So they had one of them, like the biotech company, had like about over 1,000 clinical data sets, 1,000 active clinical data sets across different platforms, Slack, in the cloud, the different databases. The aerospace company had about 10,000 CAD files across multiple versions, process documentation that's done in 158 different locations. The quality specification was maintained by literally individual engineers on their own personal hard drive or cloud accounts. So not at a specific location set by the company itself or the firm, but it's by just one guy. That is kind of dangerous. It centralizes everything together. I would like to maybe talk a little bit more about pharma, although software is up there. But well, I'll talk about like some industry-specific issues we see. For pharmaceutical clients, the clinical databases are more valuable than individual patents because they have much more information in them. Research protocols reveal competitive strategies and experimental approaches. So that doesn't necessarily is something that patent lawyers think about. International clinical trials with complex data, they can create some sovereignty issues. You know, if you have, I'm not going to say which client we did work, but Novartis is one of our clients, and it's a multinational company. In manufacturing, again, CAD files that are process documentation are really important. Quality specifications usually give you competitive advantage in production efficiency, whether they're assembly lines, whether gathering different parts from different companies and assembling them together. Execution systems, they have optimization algorithms worth millions of dollars. In the distribution clients, we see precision precision targeting really gives you some competitive advantage, which is by finding out how to optimize the route and how do I focus on which client and what they need. A lot of machine learning goes into that. So pricing models, they can expose profit margins and competitive positioning. Logistics algorithms, they provide efficiency advantages. Supply chain data, this is becoming more and more important now post the tariff world. You know, Trump introduced tariffs in the beginning of the year, and it changed a lot of things for clients. One question we usually get here is, can industry-specific collaboration tools contain actual litigable IP beyond software platforms? So by talking about like Slack, when we talk about industry-specific collaboration tools, a Slack or iMessage or something like this, yes, if they contain sector-specific trade secrets and competitive intelligence. Pharma companies use platforms like Viva for clinical data and regulatory submission. Manufacturing firms rely on product lifecycle management systems for CAD collaboration. Those are important. Distribution system companies use industry-specific CRM and logistics platform. These specialized tools often contain more valuable IP than the generic collaboration platforms because they store industry-specific competitive intelligence and operational knowledge. If you have IP that lives in a personal account or unauthorized tools, what happens? This is a complicated area. Complex ownership issues will be requiring industry-specific legal analysis. But if you're a pharma researcher using personal cloud accounts for clinical data, this creates a HIPAA compliance issue and patient privacy risks. Manufacturing engineers storing CAD files personally may violate export control regulations and quality system requirements. Distribution professionals maintaining customer lists personally raises privacy compliance and competitive intelligence concerns. So to resolve this, we have to focus on which industry are we in. This is called unstructured data storage, scattered across multiple places. We see this all the time. And this is not a problem that happens because the employee did it. The employee is the manifestation of the symptom. The cause is lack of action at the C-suite. You should have, so the general counsel or the lawyers involved should tell the C-suite, we need to have something called the journey of the data. This is something we do a lot when we meet with new clients. Can you describe, if you especially when you talk to the boardroom or C-suite, can you describe the journey of the data? Forget about even your processes. Who has access to it? Where is it stored? Most of them cannot do that. How are we doing, guys? I hope I'm not throwing a lot of tech jargon at you. Okay. So cloud and software as a service, they sprawl across different departments. And that's really the biggest problem we're seeing right now. You could be at your home, working from home with your phone, interacting with somebody, and then with your laptop, and then uploading something here. And then, you know what? The company uses Microsoft, but I'm a Google guy or Google girl. I love to use Google Sheets and Google Docs, and then it gets distributed. So there's no policy from the top to say this is what we use, and this is what we do not use. And setting up that policy really is important. Okay. So this is not specifically one case study, but I'm just talking about in general, what patterns we see. In the pharma industry, the clinical data heist is when a clinical databases represent years of research get stolen. Imagine a senior clinical researcher who manages multiple drug development programs with access to patient response data, and adverse event patterns, efficacy benchmarks, a lot of technical jargon. The researcher over several weeks systematically would download these clinical data sets under legitimate pretenses like preparing regulatory submissions or conducting meta-analysis, which does happen a lot in the pharma world. The exfiltration is not just raw data, but analysis algorithms, patient segmentation models, competitive intelligence gathered from investigator meetings. We see that a lot. This is the pattern that we've seen. In manufacturing, engineering intelligence theft would be where, again, CAD files, process documentation, quality specification. And the third actor is a senior design engineer with access to current and historical product designs, manufacturing processes, and supplier specifications. So how does the heist happen, or the exfiltration? Using a legitimate business access, the engineer would download the CAD libraries, process optimization databases, quality control procedures, and supplier relationship data, which really is important because essential relationships are between people. The person is working for the company, but it's between two entities. And the sophistication would include accessing version control systems, getting development history. This is important when you talk about what development happened and when we moved from phase 1 to phase 2 to phase 3. Why did we do that? Usually have documentation. The engineers will say, this mistake we found in version 1.0, that's why we moved to version 2.0, and we did this because of blah, blah, blah. Having the documentation really is important because it tells you the journey of the process. Let's go to distribution. In the distribution, customer databases and pricing models really are important. The typical insider is a sales director or operations manager with broad access to customer relationships and operational intelligence. And what do? They systematically copy the customer databases, pricing algorithms, and organization and historical sales data, customer preference profiles. So what do we find across different industries? Forensics investigation always follow predictable methodology. The endpoint analysis is when you're looking artifacts of data transfers, whether USB devices, whether uploading from a laptop, but that's something that always reveals data. Access log, this is very important too. Who accessed what at what point? File server records, database access logs, application usage patterns. You can find systemic data collection outside of normal job responsibilities. The communication that you find, in that you'll find like emailing metadata, meeting records, and recruitment coordination, intelligence gathering, irrelevant of the industry. Usually this will end up with multi-million settlements and injunctive relief for that. I had more cases, but I wanna push along because we only have 5 minutes. Charmaine, at 12:30 we stop, right?
Yeah, 12:30.
Okay. So timing is really the most important thing across all industries. whether you're doing protecting pharmaceutical research data, manufacturing specification, or customer intelligence. The universal immediate action triggers should be within 24 to 48 hours. You should be able to respond and get somebody involved. Key employee departure to competitor. All of a sudden, a competitor has a product similarity. This is a universal. This doesn't happen in a specific industry, across different industries. So that means clinical researchers joining competing drug companies, manufacturing company, design engineers moving to equipment competitors, and distribution sales directors joining logistics companies. The domain is consistent, deep domain knowledge combined with competitive intelligence advantage. Unusual data access patterns before resignation. You need to find people, let's say somebody hands in their 14-day, you should start, and if that person is in an important capacity, you should have people get involved and do forensics analysis and see if anything has been stolen. Now, for cross-industry warning signs, for example, in pharmaceutical companies, clinical databases access outside of normal research activities, or downloading research protocols by the departing staff, regulatory documents viewed. In manufacturing, CAD file downloads outside of current project scope, process documentation access viewing, quality specifications. We've seen that every now and then. Distribution warning signs, customer database exports outside normal sales activities, pricing model access by departing staff, competitive intelligence downloads by employees with strategic responsibilities, and logistics algorithms. These are usually people with a title like director, manager, senior vice president. So it doesn't matter what industry you're in. So suspicious behavior usually includes large data downloads, after-hour access to sensitive systems, personal email forwarding spikes. So from your work email to your personal email. I'll give you like a quick story. One guy in AI. Well, no. It's a form of AI, not the AI that you guys think about, like generative AI, but like algorithm analysis for financial services. He resigned from a financial institute and was about to join another one out in Chicago, and he opened up Google Gmail on the Gmail webpage on his work laptop, and there was a big algorithm that he created an email and saved it as a draft and copy and pasted the algorithm into that draft. So he didn't send any email. He just opened up the browser, copy and pasted the algorithm into the email, and hit save, so that he can go home and look at it from another lab. And we were able to help prove that he did that. It was a complicated case, but the financial institution, because of SEC compliance and FINRA, they already had some good cybersecurity systems to help us prove that he did copy and paste. Legal triggers would be cease and desist letters, receiving and sending them, discovery disputes, where we get involved a lot with technical evidence, and expertness like myself, who needs to do a code comparison and find out, is this the same or not? Action items that you can start with immediately. This week, universal actions. You have to inventory high-value digital assets across all systems. Have a list of them. Enable access logging on critical databases and repositories. Everybody should have a username and a password, and people should be able to monitor that and control that. Find out who's accessing what. Review employee permissions across cloud platforms. This needs to be handled. So all of those are very important. This is something you can do immediately. For this month, if you're in pharma, clinical database monitoring, research protocol protection, manufacturing, you can have CAD access controls, process documentation security. This also applies, by the way, to software development firms. In distribution, you can do customer database protection, pricing model security. For the quarter, across industry IP security assessment, you can train your legal team on digital evidence preservation, and we can help you with that. And employment agreement updates for digital assets to make sure, anything happens, litigation will start. I believe, and I'll stop here. We'll open up. I'll stop the share here, but thank you guys, and hopefully this was interesting for you.
Thanks a lot, Ahmad. How do people keep track of folks coming in and out of their system? Is there software for that?
Not one software specifically, but you have to have, usually you have logging systems that you can work with. I mean, so you can have like logs, access controls, identity management tools. So for example, if you're a Microsoft shop, you have Azure and you have something called identity access management, which tells you who accessed what. Microsoft 365, that has access logs in it. They capture username, email, time of access, IP address. If your company is somewhat advanced in cybersecurity, you'll have CloudStrike or Microsoft Defender for endpoint. Endpoint monitoring, that's when you see like USB access or something like this. So depending on the companies, Microsoft versus Google Cloud versus AWS. There's not one specific. If I was a startup, I would have suggested one specific product, like my product. We're not a startup. We're a service provider, just like you guys are service provider. We work with whatever you guys have. And because every company has its own infrastructure, its own history, and its own technology stack. So there's no one size fits all solution for it. But what you have to think about is endpoint monitoring, logging, audit trails. AWS has that. Microsoft 365 has that. Identity and access management, which is called IAM. I hope I'm not too technical, but this is something you should be aware of. Maybe guys in the audience, what cases are you guys seeing? And I don't know if that's interesting, and issues that you guys have witnessed. Okay. Okay, let's talk about what kind of like protection, like for example, database protection for pricing. Usually, a budget that you should align for that is between 15 to 50K based on it. If you have a classification system for your IP, not all digital assets is the same protection level. Core algorithms are top tier, and standard IP is general code and documentation. So you have to use the proper mechanism for that. You should have a forensic response plan where you should contact experts to identify and look at whenever the IP theft occur. Vendor selection is really important. So find vendors who can provide these logs and these access points. Not all forensics firms understand what legal admissibility requirements are. You have to navigate HIPAA quality systems, privacy regulations. Yeah, this is another thing I've noticed with people.
Do you have any war stories you can share?
I'll have to anonymize some of them. I had it in one of my slides actually. Well, so the engineer who was doing copy paste, it was a big one because it was a complicated algorithm, and he was just saving it as a draft. And then he got in the car. He was going to go home, and the bank or the financial firm had good cybersecurity engines already, and was able to come in and help us build the journey to come up and find what happened. So they had to have good cybersecurity. I'll give you a code base. So a fintech company was thinking about suspecting a senior engineer was trying to get prep. This is a separate story. So proprietary trading algorithms and they were thinking this guy's trying to do something with them before exiting. So there's something called Git commit logs. Git is when you check in the code base, where the code base resides. And it has logs in it. And we found out that this guy, he downloaded about 1,200 files, like within like hours of giving notice. And the endpoint security tools that I mentioned from Microsoft 365 or other entities, he used a personal USB drive. And then he had like a scripts uploaded to a private Dropbox filter. So the fact that we can build this timeline became the backbone of a successful injunction. Another wartime story. Slack. You guys are familiar with Slack and usage of it. So in Slack, we can find multiple screenshots marked as off the records. Figma is a drawing tool that's used a lot, which has URLs, diagrams that were spread across. Slack export metadata showing read receipts by the acquiring firm's engineers. So one firm is hiring another firm, and the engineers looking at these, and we can prove that the engineer didn't see this. Yeah, those are like one of the big ones. A lot of the times when we get involved, it doesn't even have to reach full litigation yet, because we can prove, assuming we get involved in time, we can prove. So what you have to think about is the journey of the events. And the more data we have, the more we can show the progression, building the case properly. The more discrete or analog, the more disconnected that the events are, the worse it looks, because the opposing lawyers could say, no, he didn't mean that. He was doing something else. I'll give another wartime story. While
Have you-
anonymizing. I'm sorry, go
Have
ahead.
you found, so let's say someone catalogs their IP.
Yeah.
Timeframes for protections, like in the different spaces, what you have found has been useful for folks, and what has not been necessarily the most useful protections in addressing these kinds of things.
But by things, you mean cataloging IP?
Like the breaches.
So like when someone catalogs their IP, the benefit of it versus for addressing breaches is, if I'm understanding you correctly,
Yeah,
when you catalog your IP, we can have timestamped version histories. So we can look at when you know which IP is important for you, and access logs are very important. So we can have timestamps saying at this point this happened, who accessed this one at what point. Part of the compliance on a high level, without talking specific industry, but in general, in compliance, let's say, for example, the crown jewel is this file or this database. And let's say only Bill has to have access to it. We would even say Bill's access to that should change every like 90 days. It should have a different passcode. So we'd have B Samuels, let's say that's your name or your login. The password in it, we'll put it in a separate file and change it every 90 days, or ask you to change it every 90 days and monitor your access logs to it. There's something called roles and access rights. So this is why it's not only software companies, but all companies have to be involved and have good infrastructure and cybersecurity analysis, because you can assign access roles to what IP. Only these 4 engineers can access this model. Only these 3 guys can access that model. By assigning that, you limit the amount of attack vectors that can go in. That in reality, a lot of companies is just one access. They have one email. Let's call it tech support at charmeanscompany.com. And you don't know who accesses tech support. When you go to ask them, oh, this girl would use it, that guy would use it, we share the password. That's no good. So cataloging the IP is important, and then around that you can create your own mechanisms and tools and algorithms for it. Using forensics early really has been important. Now, what is hurtful and is what actually is a waste of time is you catalog it without retaining the metadata. So let's say, for example, you catalog the IP and you put it in some folders, but you don't have the tools or the mechanism to see who have no access logs. It's just a waste of time. You actually made it look like a better target. Or again, I'm not a lawyer, but I work with a lot of lawyers. Over relying on NDAs or contract language, that people can get around that. So you should have access logs. NDAs I'm sure NDAs are important, but they don't help if you cannot prove the misuse. You have to prove that this happened. So you need technical evidence that data was taken, used, accessed improperly. Another point is the cloud oversight. Weak oversight of what happens in Google Drives or Slack or Dropbox. IP often lives in these Google Drives, Slack, Notion, Zoom recordings. But companies rarely do log or restrict that access. And after the breach, we discovered that the audit logs were disabled or retained for a short window, and that's it. Another problem we've seen is that we come in as forensics, but after there was an internal cleanup. So let's say some issue happened, IT would re-image the device. That means recreate it or deactivate the user accounts or close off cloud access, which is very dangerous. Because let's say, for example, the engineer left, and the engineers, I don't want to pick on, let's say it's me, or let's say it's Sharmin Woodall. They would disable Sharmin Woodall at the company.com, and we lost all the metadata. So we should get involved very fast. So it's not about just having IP documented, it's about whether you can defend it and how it was accessed, when, and by whom at a court level. You should, if you're talking to C-suite executives and board of directors, you should tell them we need to be able to look at the journey of the data. And from there we can start building like an access map and talk about roles. Like, for example, we were talking to the general counsel of a hospital system in New York, and the first question I asked the general counsel is, do you know how the data moves in your company, in your hospital system? And the response was no. They have a chief privacy officer, chief patient officer, but the response was basically no, and something you should be aware of. I don't want to scare. Yeah.
Sorry, go ahead.
I don't want to scare people about this, but being preemptive and cleaning up before really is important. Taking action before really is important. It's the equivalent of, the analogy I told you about, go lift some weights, go exercise, stop with the sugars, which is really not that much work, versus somebody who gets a heart attack from diabetes or from whatever, and then, you have to have radical reconstructive surgery, something like this, and then you have to go rehabilitate. Preemptive supersedes post-action.
Do you find there are any particular industries that you're finding the most breaches?
Well, I mean, I can say software, but let's talk about this idea. There's different types of breaches. Economic activity can be thought of as products and services. I'm a service provider, you're a service provider. I don't have a secret sauce per se. We work with companies, we're not a startup. The people who breach us would be people who actually are just trying to lock down our systems and want crypto, basically. People who just want to say, you don't organize the system until we get crypto. That is a specific type of hacker. The products companies that actually have a secret sauce, as in IP, they would have people snooping in and looking at it and observing for a while and then trying to download. Those, I would say, healthcare and life sciences is pretty high. Financial services comes every now and then, but to be honest, financial services companies, at least the ones in New York City, are doing well. Meaning, we have big names in our portfolio: Goldman Sachs, Morgan Stanley, Barclays, Citibank. It was like a small project. So I mean, not small, but we did some work with them. But they do have their act together. Why? Because usually these are multinational entities and they have to respond to different regulatory environments. So financial services, not as much as healthcare sciences and healthcare and life sciences. SaaS, especially AI startups, we find source code happening there a lot. Not as much though. Yeah,
Where are the attacks coming from?
yeah. I mean, that's a good question. So every now and then, depending, but in the healthcare and life sciences, we're seeing IP addresses from mainland China and North Korea. Essentially, at the end, there is some cross-industry, industrial espionage between companies. That does happen. But the majority of cases, maybe 45% of cases, let's say 45% of cases are coming from IP addresses from mainland China and sometimes North Korea. And then 55%, the rest, is just distributed among different things. A California company hired an engineer from a New York company from upstate New York, or there's a lot of investment into chip manufacturing upstate New York. So something like that happening. A Midwestern company, where they do a lot of prop trading in financial services, hired one of the big traders, big algo traders in the banks in New York City. We do see that every now and then, but it's distributed across different sectors.
What's the right time to call you or someone like you? Like, do you design the systems for
Of course.
place? Yeah.
The right time is like within 24 hours. 24 to 48 hours really is important. Some people might think we have to disable or something like this. Actually, the right time should be before. A proactive window for design and for legal and forensics readiness really is important. We have a course. I don't know if I can mention the course that we give Bill on this Zoom call. Can I mention it? Can I put it in the chat box? So this is because I've seen this happen so many times. I'll put it in the chat box. My philosophy: this is a cybersecurity course, but if you go through it properly, and this is designed for the board of directors, for the C-suite. My philosophy from seeing in this, from experience where I've seen, is that the breach doesn't happen because of IT mistakes. It's lack of response on the C-suite at the board level, not because of tech. Lack of response, lack of vision. We see this again and again and again. The engineer was able to abscond with these files. Why? Because nobody at the board level said, you know what, we have to access logs. We have to create journeys. We have to make sure at any given moment in time, without using too much technical jargon, I can see how the data moves, who accesses what, at what time. We have to have different roles and access logs. We have to have access roles, I'm sorry. So Bill should be an admin, a super user, only if he is the VP of this. That role should not be, have read only, not read and write. I was doing a talk for the internal auditors conference, and part of it, the internal auditors, the third line of defense, that usually they try to raise these red flags. And these problems arise a lot. A lot of people put
to lead a project.
Sure.
Like that. Yeah.
Sure. Depending how big the firm is, if there's a C-suite, it should be split. Some people have chief privacy officers. Hospital systems have chief privacy officers. That's a good question. It should be COO/chief legal officer, general counsel. Doesn't necessarily have to be the CTO. CTOs usually don't like to work with us because, if they're doing their job, it should be the CTO essentially. But the way we get in is through other C-suite executive, not the CTO. A good CTO should be able to do that. But even with that, you have to have the proper relationships between a CTO and, for example, chief information officer. Does he report to him? Does he report to the board directly? So it's spread out, honestly. Based on industry, if you ask me which industry, I can answer more. For example, in pharmaceutical, chief privacy officer, chief people's officer should be involved in that too. It's cross industry, across different roles. But in this course that we give, it shows you on a high level how, like for example, an incident response. How can you how to make one? What should you have for the next 30 days? Action plans for the next 60 days, for the next 90 days. Um, not only not only how to protect from a breach. A breach might happen with a high percentage of accuracy. So expect the breach is going to happen. How to react from it? How to come back from it? There's something that I think they should be taught to called digital hygiene. How to explain to the employees how to maintain good digital hygiene, how to interact with systems properly, and it should be taught honestly. I don't know if this makes sense for everybody or not, but hopefully this is not too technical. If the design, if we come in early and we this is the proactive part. If we come in early and we're designing the systems for you, or building, or we get involved with new AI tools, cloud platforms are being adopted, we can design the environment so that the cybersecurity is by design, not a reaction, and that evidence will exist for that. That means proper audit logging, structuring IP repositories with traceability. The access rights, we assign access rights defensively, and we make sure data preservation is possible and court admissible. The reactive window, which is, let's say a suspicion of misuse or breach, departing employee, that's what you should be thinking about. A competitor releases something suspiciously similar to you. Unusual activity. If we come in and we can come in early enough before your IT disables their systems, we can preserve the trail, logs, metadata, devices, email, shape discovery, negotiate from a position of evidence-backed strength. That's how we can help your legal team.
How long does it take, like, on average? I'm sure that each case is different, but to gather that information.
Oh, depends. Depending how big. We had one case where the person, well, okay, best case scenario, 5 to 10 days, honestly.
Okay.
But it could be 1 to 2 weeks, could be even more. That I gave you best case. A standard scenario, but yeah, 3 weeks. We have to pull logs from multiple systems: Google Drive, Dropbox, Git, local machines. We're talking about partner or co-founder dispute or AI model. We've done stuff where it was about like 3 months. We had like remote workforce, no logging or very poor logging, third-party vendors, international cloud data. So, or we had to do some deep reverse engineering.
Got it.
Yeah, yeah. Yeah. It all starts with being proactive and having good cybersecurity posture and response plan. And that should not be. It shouldn't be high tech buzzwords. When we build this for our clients, I try to make it as simple. I don't want to use the word dumb it down because the C-suite and you guys are intelligent people. It's just different worlds. I try to use words and analogies that make sense for you. I'll give an example of a case where it was the reverse of a case connected to this, but not necessarily in IP per se. But we had a company was hiring another firm, and the firm in the US, a firm in New York, had a managing director. The guy was supposed to log into a system, update something, and hit submit. The guy's story is that he did this. He had, on that specific date. It was supposed to have a specific. He goes in, logs in the system. He did blah 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 blah. He did everything. He hit submit. The circle came up, says saving, and then says save successfully, but it never saved it, which means that firm could not perform a task that was supposed to task on that date. So the plaintiff comes in 6 months later with like an eight-figure lawsuit against them. Now, when I talked to the guy, so we were brought in to do forensics to help with the defense. And the guy's an old guy. He said, oh, there was always gremlins in this system. So, which is not very technical. So we did some analysis and we scanned everything. So the guy was the head of the department with 3 floors and different machines, and he would work with his team. And at least the story is that he doesn't have to be in one office per se. After a while, I came up with the idea is that let's say it's Bill again. So probably your login is B Samuels. I said, let's find B Samuels, trace that word across different systems. And the guy claims it happened, let's say mid-March, March 15th. So like give from March 1st to March 30th, 15 days before and after. After quite some research, we found that B Samuels tried to contact the server on March 16th or something, 4 times in 1 second. B Samuels, B Samuels, B Samuels, B Samuels. When it hit the server, it didn't do an insert or delete or an update or modification, but it tried to do something. Now we could argue that maybe the Verizon Wi-Fi timed out or something, or like internet was kind of slow or something on that day, because that behavior is abnormal. And this is usually the lawsuit between insurance companies. So our findings helped lower the proverbial axe that the insurance company was waving at them from 8 figures to like 7 figures. Just by finding something like that.
Anyone else have any questions? You've answered all our inquiries, Ahmad. Thank you for your presentation today.
Sure.
We can open it up if others have any questions. Feel free to fill us in on a last war story.
Oh, me? Let me see. So let's say, well, a healthcare company was about to exit. They had some AI in them. They discovered unusual unbound network activity, and there was an intern there, and the intern had been shadowing engineers, which means working with them, following them, and seeing what medical imaging they were doing. They compressed and picked up training data, model weights, which is kind of important about their AI algorithm, and uploaded it via personal Google Drive. And weeks later, this intern was hired by a foreign competitor with almost the same product in beta. So in healthcare and in pharma, if you go release a drug and you go from alpha to beta or something like this, like your valuation explodes. So we did a real-time timeline reconstruction with Git logs, endpoint monitoring, VPN usage, because there was a international, and drive metadata. And we were able to construct, at least in terms of the opposing counsel, that the model question was exported in compressed chunks during off hours. And we provided the full export declaration and forensic affidavit for pre-litigation negotiation. So that kind of helped them.
Doing that kind of dive.
Well, I'm sorry?
Doing that kind of a project, what should a company expect the cost to be?
Definitely tens of thousands. Yeah, I mean, if could reach up to 6 figures.
Yeah.
Most forensic IP investigations are between 35 to could be up to 150K. Initial forensic triage would be maybe 10 to 20. Evidence preservation review about 15 to 50K. Me as an expert witness could be another 25 grams up and higher. Yeah, 6 figures, full litigation support. If we're just limited scope, 25 to 30K. But the cost is not the forensic team, it's preserving evidence early. Because if you have evidence, it's different than having the legal team rely on assumptions instead of facts.
Well, thank you so much for the presentation. This was great.
Thank you for having me.
And I believe, Sharman, can we confirm the next, in July?
That's going to be the second Tuesday of the month, so July 15th is our next round.
You're a little bit quiet.
Yeah, I don't. The registration is open. Feel free to visit our website and register for our next session as well as future sessions.
Okay, great. All right, on that note, we'll let everybody get back to the things that keep them otherwise busy. Thanks, everybody, for coming, and all feedback and considerations are welcome. Thank you.
Hey guys.